Imagine waiting years to reunite with your loved ones, only to see USCIS processing time spike unexpectedly. Families across the United States are in shock as new updates reveal that I-130 petitions for spouses, parents, children, and siblings are facing unprecedented delays. What was once considered a predictable wait has turned into uncertainty, anxiety, and frustration for millions of applicants. Whether you are applying for a spouse visa, petitioning for your parents, or trying to bring a sibling into the country, these 2026 updates have massive implications for families across the globe. In this video, we'll break down the shocking new changes, why delays are surging, how each family category is impacted, and what steps you can take to protect your application and stay ahead of the backlog. This is critical information that every family-based immigration applicant needs to know. USCIS has just released updated processing timelines for I-130 petitions, and the numbers are staggering. Immediate relatives, which includes spouses, parents, and unmarried children under 21, were once processed relatively quickly compared to family preference categories. Now, even these immediate relative petitions are experiencing extended wait times in some cases. The impact is being felt everywhere, from families waiting for spouses to join them, to adult children and siblings who had hoped to be reunited years ago. These changes are not just statistics. They represent real families, disrupted lives, and plans put on hold indefinitely. For spouses of U.S. citizens, this new surge is especially concerning. Couples who had anticipated a 1-year or shorter wait for their petition to be approved may now face multiple years of uncertainty. The emotional toll of such delays is significant. Many spouses live apart for extended periods, and plans around housing, employment, and family life are disrupted. For international couples, the stress is compounded by visa interview scheduling, embassy delays, and travel restrictions, making what should have been a joyful reunion a source of anxiety. Many applicants have shared stories of broken plans, postponed weddings, and temporary living arrangements caused by these prolonged timelines. Parents of U.S. citizens, though considered immediate relatives, are not exempt from the impact. With the surge in petitions and backlog accumulation, even parent petitions are taking longer to process. Elderly parents, who often require medical care or consistent family support, are facing separations that stretch beyond expectations. These delays have real-life consequences, including health challenges, financial stress, and the inability to make long-term plans for family life. The emotional strain is compounded by the uncertainty, as families cannot predict exactly when their petitions will be approved. Children, both minor and adult, are also impacted significantly. While minor children of U.S. citizens are typically treated as immediate relatives and prioritized in processing, adult children fall under family preference categories, which are heavily impacted by backlogs. For minor children, prolonged separation from parents can affect schooling, mental health, and social stability. For adult children, delays can mean years of waiting before they can live legally in the United States, which affects education, employment, and personal life decisions. Families are struggling to balance these long waits while maintaining connections across borders. Siblings of U.S. citizens are facing some of the longest waits of all. Placed in family preference categories with strict annual limits, sibling petitions are now affected more than ever due to the 2026 surge in I-130 processing times. Some applicants who filed petitions years ago are only now approaching interview dates or approvals, and for new applicants, the waiting period may extend well beyond a decade, depending on the country of origin. This delay disrupts family plans, holidays, and emotional well-being, as siblings separated by oceans and borders remain apart for years. It's a reminder that immigration is not just about paperwork, it's about human lives and connections. Several factors are driving this surge in I-130 processing times. USCIS has been grappling with staffing shortages, high petition volumes, and ongoing system updates to improve efficiency. While these upgrades are meant to modernize the process, they also create temporary slowdowns. Policy changes, evolving eligibility criteria, and global factors such as political unrest, pandemics, or travel restrictions further contribute to delays. The combination of these challenges has created a perfect storm, affecting every category of family-based petitions. Another key factor is the applicant's country of origin. USCIS prioritizes petitions differently depending on country quotas and annual limits. Applicants from countries like Mexico, India, the Philippines, and China, which have historically high petition volumes, are facing significantly longer waits than applicants from countries with fewer petitions. This disparity creates frustration among families who feel the system is inconsistent, leaving them wondering why their wait is so long while others proceed more quickly. Processing times can also vary depending on whether a petition is filed as an immediate relative category or a family preference category. Immediate relatives generally have no annual caps, yet the current surge in 2026 has affected even these petitions due to accumulated backlog and administrative processing delays. For family preference categories, the impact is even more pronounced, with adult children and siblings often waiting years longer than anticipated. This reality forces applicants to adjust expectations and prepare for extended separation, which can disrupt careers, education, and personal plans. With these delays, it's more important than ever to ensure your petition is complete and accurate. Missing forms, incorrect documents, or inconsistent information can add months or even years to the waiting period. Applicants are advised to carefully review all submissions, maintain organized records, and respond promptly to any requests for evidence, RFEs, from USCIS. A single mistake can result in further delays, compounding the already lengthy processing times. Legal guidance has also become increasingly critical. Immigration attorneys can help applicants navigate these complex timelines, understand category-specific rules, and advise on options for expediting cases if eligible. Professional advice can also help avoid common pitfalls that lead to processing delays. Families with complex situations, such as mixed-status households or multiple petitions, should consider consulting a qualified attorney to ensure their cases remain on track. Technology updates by USCIS are another contributing factor. The agency is modernizing its systems to handle electronic filing, case tracking, and document submission. While these upgrades aim to streamline processing in the long term, in the short term, they can slow down approvals, especially when transitioning from older systems to new digital platforms. Applicants may notice longer processing times during these periods of adjustment. The emotional impact of these delays cannot be overstated. Families separated for years face stress, anxiety, and feelings of helplessness. Spouses living apart, parents unable to care for aging children or grandchildren, and siblings separated by international borders all experience real consequences. Staying connected through video calls, regular communication, and community support networks can help mitigate some of these challenges, but it is no substitute for physical reunification. Families must prepare for long waits while maintaining hope and resilience. It's also important to recognize that USCIS processing times fluctuate. They are not fixed and can change based on petitions filed, adjudication capacity, and external factors. Staying updated through the official USCIS website is essential. Applicants should monitor processing times for their specific category and location, as these updates can provide insight into expected wait periods and help families plan accordingly. For those filing in 2026, patience is critical, but proactive planning is equally important. Keep copies of all submitted documents, maintain accurate personal information with USCIS, and promptly address any requests for additional information. Understanding the type of petition, its category, and the applicant's country-specific quota can help families anticipate delays and avoid surprises. Strategic planning and preparation are key to navigating this challenging period. While the situation may feel overwhelming, there are steps applicants can take to improve outcomes. Maintaining meticulous records, consulting with experienced immigration attorneys, and staying informed about policy changes and processing trends can help mitigate the impact of these delays. Families should also explore alternative pathways where applicable, such as employment-based visas or humanitarian programs, while waiting for family-based petitions to process. In conclusion, the I-130 processing surge in 2026 represents a significant challenge for families seeking reunification in the United States. Spouses, parents, children, and siblings are all affected, with timelines longer and more unpredictable than in previous years. While the situation is daunting, understanding the reasons behind the delays, staying organized, and seeking professional guidance can help families manage expectations and maintain hope during this uncertain period. Reuniting with your loved ones may take longer than expected, but with preparation, persistence, and informed decision-making, it remains achievable. USCIS has emphasized that patience, accurate filings, and ongoing monitoring are essential. Families impacted by these changes are not alone. Millions are experiencing similar frustrations. By staying vigilant, staying informed, and planning strategically, applicants can navigate these challenges more effectively and maintain confidence that their petitions will ultimately be adjudicated.